So let's start discussing the next question. So next question was asked in 2021. Now the question says a legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which one of the following articles of the constitutions. So basically the questions try to ask that if a parliament or any state legislative assemblies or council through law, through passing a law, through passing a law, they provide an unlimited power, unlimited power to executive or administrations. Right? Now the functions of the executive and administration is to implement the law, is to implement the law which enacted by the parliament. Now if suppose that executives or administrations has an uncontrolled or unchecked power while implementing the law, so it means now these executives who gain through the law and uncontrolled power will act as a biased institutions, and due to their biasness towards the implementations, it will create an inequality in society, inequality of societies, right? So if it creates an inequality, it means it is violating the equality, it is affecting the equality of the social structure. So equality has been violated, it means article 14 which talks about the equal protection of equality before law and equal protection of law will be violated if the executive or administrative authority were provided with the unguided or uncontrolled discretionary power. It means they want, whatever they want they can do, and if the executive, the authority or administrative authority, whatever they do or they have an uncontrolled power, so this will impact the equality which will create an inequality in the society. So according to this, the answer to this question is article 14. Clear? Now if you see that article 14 of the Constitution of India guarantees the right to equality before law and equal protection of laws. This means that no person can be treated unfairly or arbitrarily by the state or its agency. Now, if talks about its agencies, means it is also talking about the executive and administrative authority, the two which was asked in questions. A legislations that confers a legislation that confers unguided and uncontrolled discretionary power on the executives or administrative authority in the matter of applications of laws violates article 14 because it can lead to arbitrary or discriminatory decision making. So that will be unequal inequalities in society. Discretionary power that are unchecked or unregulated by any legal standard can result in unfair treatment which is against the principle of equality before the law. Thus, such legislation is unconstitutional under the Article 14 as it undermines the guarantees of equality and fairness in the application of law. Right? Now, the second option, that is Article 28. So, Article 28 is a part of right to freedom of religion. So, it says that Article 28 of Indian Constitution protects the freedom of religion in educational institutions. So, it ensures that state funded educational institutions do not provide religious instructions. Individuals have the freedom to pursue their own religious belief. Individuals can choose not to participate in any religious activities in school administrations or educational institutions. And next, Article 32 of the Constitution guarantees the right to move the Supreme Court for enforcement of fundamental rights when they are violated. And Article 4, the last options, that is Article 444 of the Indian Constitution, state that the state should work towards establishing a uniform civil code for all citizens of India. This, this article is a directive principle, not a fundamental right. So through this, we can say that answer to the question is Article 14 is a violations if it is violated if the unguided or uncontrolled discretionary power is provided through law. Clear? Let's move to next question. Next question was asked in 2020. So the question says, which one of the following categories of fundamental rights incorporates protection against untouchability as a form of discriminations? So as the question itself suggests that out of the set, there is a category or types of fundamental rights, and out of the types, which one of the fundamental rights categories fundamental rights that include the protection against untouchability. So first of all, we need to see the types of fundamental rights or classifications of fundamental rights. So there are 6 types of fundamental rights. The first is right to equality. Right to equality. Now this right to equality includes from Article 14 to Article 18 of the Constitutions. That more elaborately we see that Article 14, Article 15, Article 16, Article 17 and Article 18 of the Constitutions. Now the second is right to freedom. The second classification is right to freedom. Now this includes from Article 19, Article 20, Article 21, Article 21A and Article 22. The third classification is right against exploitations. Against exploitation. This include Article 23 and Article 24 of the Constitutions. The fourth classification is right to freedom of religion. Freedom of religion, that includes from Article 25, Article 26, Article 27 and Article 28. The fifth is cultural and educational rights. Cultural and educational rights. This includes Article 29 and Article 30 of the Constitutions. And the last classification is right to constitutional remedy. Right to constitutional remedies, and this is under, and this include Article 32 of the Constitution. So these are the 6 classifications or categories of fundamental rights. Now it says that which one of the following categories, so out of these categories, which incorporates the protection against untouchability as a form of discriminations. So if you see the first category, that is right to equality. So right to equality is providing an equality in society. So by the virtue of this classifications, we can say that there is it is against the discrimination. So right equality means it is against discriminations, right? If you are not aware about the exact article, so from this also you can conclude your answer that it is talks about inequality, it means it is against the discriminations, right? And particularly Article 17 of the Constitution talks about that this is abolition of untouchability, right? So our right to equality is about, that is particularly Article 17 is talks about protections against untouchability as a form of discriminations. This right against exploitations is concluding 23 to 24, right? This is about exploitations. Article 23 talks about an bonded labor, human trafficking, right? Whereas Article 24 talks about an prohibitions of child labor, right to freedom, that is from 19 to 22 of the constitutions, freedom of speech, expressions, movement, residence in India or any part of India, practice any professions, these kind of rights comes under the right to freedom. Right to constitutional remedies, that is Article 32 of the Constitution that talk about the right to constitutional remedy. So this discriminations against a discrimination, that is right to equality, that is from Article 14 to 17 of the Constitutions. Clear? Now here, if you see, detailed descriptions about the right to equality has been provided. So right to equality is enshrined in Article 14 to 18 of the Indian Constitutions and protects individuals from discriminations. So right to equality includes Article 14, that is equality before law or equal protection of law. Article 15, that prohibits prohibitions of discriminations only on ground of religion, race, caste, sex, or place of birth. Whereas Article 16 talks about equality of opportunity in matter of public employment, that no citizen shall on ground only of religion, race, caste, sex, descent, place of birth, or residence of any can be discriminated. Whereas Article 17 is abolition of untouchability, and Article 18 is abolition of title. So all these five articles included into right to equality, and all these talks about it, talks or give a protection against discriminations. Is it clear? Okay. Now let's move to the next question. Now next question was asked in 2020. So let's see the questions. So the question says, consider the following statement. Here we have given two statements. So let's see the first statement. The Constitution of India defines its basic structure in terms of federalism, secularism, fundamental rights, and democracy. So if we see, if we bifurcate the first statement in two half, so second half of the statement is true, that federalism, from this the federalism, secularism, fundamental rights, and democracies are part of basic structure. So they are basic structure. So second half of the first statement is true. But if we talk about the first statement, that is Constitution of India defines basic structure, this is untrue. So because of this, the first statement is not true. Now why it is untrue? Because the basic structure is a product of is a product of a judgment of Supreme Court, and particularly through the Keswananda Bharati case 1973, in which case the Supreme Court has propounded the term that is basic structure. Though this term basic structure is not defined under Constitution and also not defined by the Supreme Court. So the term basic structure is not defined anywhere, neither by the Constitution nor by the Supreme Court. So because of this, the first half of our first statement, the first statement is incorrect. Now if we move to the second statement, so the Constitution of India provides for a judicial review to safeguard the citizens' liberty and to preserve the ideals on which the Constitution is based. So this is true because the Constitution of India provides for a judicial review under Article 13, 32 and 226 of the Constitutions, which says that Article 13 says that if any law made by the parliament, made by legislature, not only parliament but legislature, and if is contradictory to part third and it is contradictory to fundamental rights, then it will be then the law will be void, that is unconstitutional, right? So if any law made by the legislature and that law violates any of the fundamental rights, part third, then it can be challenged in a court, and the court will, on the basis of this, that the law violates the contradict the fundamental rights, so it is unconstitutional. So it means the this 13 has a provisions of judicial review. Again, we need to understand here that constitution provides for judicial review, but the constitution does not define the judicial review. There is no definition of judicial review is given in the constitutions, though the constitution has a provisions with respect to judicial review, right? Like article 32 is a power of the Supreme Court to issue writs, whereas at 26 is a power of High Court to issue writs in the case when violation of fundamental right has been done, right, by either by the actions of legislature or by the actions of executive. So this provisions of judicial review is there in the constitution, but still it is not been defined by the constitutions. So our second statement is true. So now if we need to find the answer that which of the following given statement are correct, so only two is true. The first is incorrect because basic structure is propounded by the Supreme Court under KVC case 1 and Bharti case in 1973, not by the constitution has not defined it. Now if you see the explanations related to the question, so it says that basic structure doctrine was established by the Supreme Court in case 1 and Bharti case in 1973, which held that the certain fundamental features of the constitutions cannot be altered by parliament through amendments. It means the parliament has a limited power under article 368. While the Supreme Court has identified federalism, secularism, democracy, fundamental rights as a part of basic structure, the Constitution does not explicitly defines a basic structure. The concept of basic structure has evolved through judicial interpretations, not by a direct mentioned in the Constitution itself. Yeah. Now, if you see the judicial review, so judicial review power in India is a fundamental aspects of constitutions and allows the judiciary to review laws and executive actions to ensure that they are in compliance with the constitutions. So here we need one thing we need to understand that the judiciary that judicial review is a power to judiciary. Now which type of power? To review the laws and executive actions. So judicial review means the judiciary can only review, only power under judicial review is to review the laws made by the parliament or legislature or state legislature and the executive actions. So it does not amount, the judicial review does not amount to any other power. Thus, it is only restricted to review the legislative power or executive actions of a parliament. Now, why it wants to judicial review, power of judicial review? To ensure that they are in compliance with the constitutions. Means the laws made by the parliament or legislature or any action of executive should be based on according to constitutions. Now, the Supreme Court of India under Article 13 and 32 can review the constitutionality of laws and protect citizens' fundamental rights. Judicial review helps preserve the ideals of justice, liberty, equality, and fraternity, which are the core values of constitutions, which the question itself says that based and to preserve the ideas on which the constitution is based. So constitution is based on justice, liberty, equality, and fraternity. So the second is true. Now let's move to the next questions. So next question was asked in 2018 and this is a repeated questions, though not exactly the same repetition, but the concept is similar, which has been repeated. And the question was, we have discussed the very first question which was asked in 2024. Let's see then. Right to privacy. Right to privacy is protected as an intrinsic and part of right to life and personal liberty. It means it is talking about the article 21, Article 21 of the Constitution talks about a right to life and personal liberty. Which one of the following in the Constitution of India correctly and appropriately imply the above statement? Now we need to find out of the given options that which is an appropriate implications of the given statement, right? So Article 14 and provisions under 42nd of the Constitutions, no, it talks about Article 21. So directly we can move to the Article 21 of the Constitutions or the options given in this for the questions. Article 4, it does not talk about Article 14, it does not talk about Article 17, that is untouchability, and it does not talk about Article 24, that is prohibitions of child labor, but it talks about Article 21 and the freedom guaranteed in the part 3rd of the Constitutions. Clear? Now for the explanation, if we move to the very first questions of our discussions. So here you can see that under the case Justice K.C. Puttaswamy versus Union of India 2017, also known as a right to privacy verdict, was a landmark Supreme Court of India case that established right to privacy as a fundamental right. The Supreme Court recognized the right to privacy as a fundamental right protected under Article 21. The court held that privacy is an essential aspect of personal liberty and dignity and is intrinsic to the entire constitutional schemes. The bench also ruled that the right to privacy is not an absolute but it is subject to reasonable restrictions. Clear? So here we can see that one of it is again a repeated concept or the questions we can say that. Now let's move to the next question. So the next question asked in 2017. So it says that in India, the judicial review implies. Now you can also say that it is a based on concept and it is a repeated concept. We are just discussed, right? So a repeated concept. Now what the judicial review implies? So it says the power of judiciary to pronounce upon the constitutionality of law and executive order exactly the same. So judicial review is related to review the act of the legislature and the activities of executive, whether the act or executive is constitutional or not, right? So this is an our answer. Now let's see why the other options cannot be the answer or what are the other answer options talks about. So the next option says that power of the judiciary to question the wisdom of a law enacted by the parliament. No, it is not about the question of wisdom, will, right, or intention of the law. It does not talk about the intentions or will of the law. It only talks about whether the law passed is constitutional or not. It is only checking whether the law which has been passed by the parliament or legislature, either parliament, either being a state legislature, is constitutional. If it is constitutional, it is not intending to questioning its wisdom, intentions, or will. So because of this, it cannot be our answer, or judicial review has, it does not mean the judicial review. Now third says the power of judiciary to review all the legislative enactment before they are assented by the president. No, it is also incorrect. First of all, it can judicial review can only apply to the act passed by the legislations, by the act passed by legislations, right? And as we all know that a bill, a difference between bill and act. So bill is a bill which is not been passed by, it is passed by legislature, but yet not assented by the head of state, head of state, right? As soon as a bill get assent of the head of state, get assent of head of state. In case of India, it is president, and in case of state, it is governor. So as soon as the bill get assent of the head of state, the bill become an act. So the statement says the power of judiciary to review all the legislative enactment before they presented to or before they are assented by the president. No, it can only be questions. It can only be challenged in a court of law once the it becomes an act. Why? Because bill is not intended to implementations. Executive of the country is not going to implement the bill. It is only in the form of act. So bill, when it converted into the act, it will be implemented by the executive. So because of the implementations which is going to impact the general people will be in a questions. So because of this it is incorrect. So always it has to be enactment, that is bill will be only it can be challenged when it becomes an act. Okay, so because of this it is incorrect. Now if we see the third last options, the power of judiciary to review its own judgment given earlier in similar different case. No, this is also not under the we can say that power of judicial review. So the last options given for the question is not a power under judicial review. So this power of judiciary lies under the court of record. Court of record. It is one of the power of Supreme Court or judiciary. It is available to both Supreme Court and High Court. So under this, what happened? So judgment of the every judgment of the judiciary will kept in archive for the future reference. For the future reference. And in the future, while referring to the judgment given by the earlier Supreme Court, judges of the Supreme Court, that can be reviewed and can be corrected. So reviewing its own judgment does not cover under the judicial review, rather it comes under the court of record. Clear? Because of this, the D is also incorrect. So our correct options is only A. Right? Now if you see the judicial review, the explanations related to judicial review. So judicial review in India refers to power of judiciary, primarily the Supreme Court and High Court, to review laws passed by the legislature and executive order to ensure they conform to the Constitution of India. That is constitutionality, or that should be according to constitutions. If a law or executive action is found to be unconstitutional, the judiciary has the authority to declare it void, that is, it can call unconstitutional. Article 13 of the Constitution gives the courts the power to review laws and are inconsistent with fundamental rights. This we have already seen in the last questions. Article 32 and 226 of the Constitution allows individuals to approach the Supreme Court and High Courts respectively to challenge the constitutionality of laws or executive actions. Clear? So these are the judicial review. And by this we come to an end to our discussions of a previous questions on fundamental rights. So thank you to everyone. Please like, subscribe and comment, and also refer to this series to your friends also who are on the same preparations mode or who are also preparing, either preparing for UPSCs or any state related services. So thank you.